Discussion, Representative Thielen.
Thank you. Mr. Speaker, I'm rising to speak in support of the measure, but with suggested amendments for conference committee.
Absolutely, in support with amendments to consider.
Thank you.
Please proceed.
Mr. Speaker, if members turn to page 4 of the bill, the three things that are at issue really are the different notice provisions. One is that Hawaii has public programs that provide immediate free or low-cost access to comprehensive family planning services. Second, to apply online for medical insurance coverage that will cover the full range of family planning and prenatal care services, go to mybenefits.hawaii.gov. And then third, that ultrasound, only ultrasound performed by a qualified healthcare professional and read by licensed clinicians should be considered medically accurate. Mr. Speaker, we know Ninth Circuit upheld similar kinds of provisions in a pregnancy center case. But when you take a look at different circuits in the nation, you realize that this issue probably will go up to the United States Supreme Court. And therefore, it's important to look at other circuits to see if our bill, as worded, those three requirements in the bill, the notice provisions, if they would withstand Supreme Court review. And we looked at both the Second and Fourth Circuits because they enjoined some parts of pregnancy center notices as compelled speech, violating the First Amendment. So the New York City Department of Health and Mental Hygiene encourages women who are or who may be pregnant to consult with a licensed provider. That was struck, and that was in the Fourth Circuit in Evergreen. Then Centro Tepeyac, sorry about that, is in the Second Circuit, and I'm sorry, I'm switching that. It's in the Fourth Circuit, and it encourages women who are or may be pregnant to consult with a licensed health care provider. And it found these provisions unconstitutional because they're requiring a speaker to advertise on behalf of the government. So that's what we have to take a look at, these three provisions. And the first provision in our bill, page 4, lines 4 to 7, it simply says that Hawaii has public programs that provide immediate free or low-cost access to comprehensive family planning services. Okay, that's a status disclosure, and in Evergreen, that's been upheld. It's simply a status disclosure. The difficulty comes when we go to the second one, which is, it's saying to apply online for medical insurance coverage that will cover the full range of family planning and prenatal care services, go to mybenefits.hawaii.gov. That's a government message encouraging women to consult with a licensed provider. And that the Second Circuit enjoined. So we're looking right here at a provision that if this goes up on certiorari, this likely would be struck. And then the services disclosure is indicating whether the facility provided or referred clients for abortion, et cetera. We took that out, so that's not in the bill. Then I wanted to go ahead to sorry about that, mention in Centro, the court applied...
Representative Ward, will you yield your time?
Speaker, I yield my time.
Thank you very much.
Thank you. In Centro, the court applied strict scrutiny to both statements And that's what's going to happen here, because the speech is neither commercial, these are not commercial operations in the pregnancy center, and they're not professional. So it's going to be a strict scrutiny test. So if you look ahead at this, that the conference committee could correct this, and I again go to page 4 of the bill, line 8 through 10, and the conference committee could rephrase the notice from the imperative to the indicative mood. For those of you who had grammar in grammar school, this would bring the notice closer to a narrowly tailored and neutral statement of fact, rather than an express or implied endorsement of policy such as exists in here. We have a government message in this second provision, this second notice provision. So the sentence could be rewritten to state, an online application for medical insurance covering the full range of family planning and prenatal care services is available at mybenefits.hawaii.gov, making it simply and in the indicative mood, and I believe withstanding any strict scrutiny challenge. So we have time to correct this, so we are not using government messaging, and we would be able to do that in conference committee. I also have some, I'd be very glad to share this with the chair of judiciary and any other members that would like to see it. I think that it's important that a measure that we put through is not, does not contain I guess, government messaging language or something that pushes the line too far and makes the volunteer pregnancy centers become government spokesmen, which they do not want to do, and I agree with that. Thank you.
Thank you very much, Representative. Kind of felt like we're in constitutional law class there. Thank you, though. Representative Oshiro.
Yeah, Mr. Speaker, I stand in opposition to this measure.
Please proceed.
A couple of points. First of all, let me adopt every single word, every single legal citation, both the New York case, the Baltimore case. My colleague from Legal Aid Days just reminds me of how important a reading of this measure is.
And so ordered, Representative.
On the her remarks?
Yes, absolutely.
Yeah, thank you very much. I'm just so pleasantly surprised, and I agree 110% with my colleague on the other side of the on the aisle here. But she's exactly spot on. I've read those Fourth Circuit cases, the Second Circuit cases, the Ninth Circuit cases. I've been following the current recomposition of the United States Supreme Court, and she is spot on, accurate, and really, I think her remarks need to be taken seriously. I'd just like to add on to several things that she may not have emphasized about the fatal defects of the bill. So besides from being a square-on violation of the First Amendment, I think there is also a violation of the First Amendment's other provision, which is religious freedom. And that's a provision that protects all of us from both having government force religion upon us, as well as allowing us to practice our various religious faiths without government involvement. I think we tried to cure the defect by taking out the offending word abortion in several parts of the bill. But I think there still lies therein a provision regarding the availability of all FDA-approved contraception. I think it's all FDA-approved methods of contraception. And I think some people may challenge that as still violating their freedom of religion, in that some people, even today, object to abortion. They don't believe that's okay with their sincerely held, deeply held religious beliefs. I also think that the bill is overbroad. I think we tried to amend some of the deficiencies to address the constitutional challenges, but I think inadvertently we have created a situation where the bill is overbroad. In fact, I asked people to go back and look at the Department of Health's testimony that was submitted to the Judiciary Committee, and therein they point out to the fact that this bill will now apply not only to limited pregnancy centers, and I think there are about 7 or so in the state, but many others who deal in this area of women's health care, reproductive rights, prenatal care, pregnancy, etc., to include hospitals. So that means all of your community hospitals, HHSC hospitals, Queens, St. Francis, Straub, Kuakini, Castle, Wahiawa, Kahuku, etc. It also would apply to any of your health centers throughout the community. I think we have over 22 of them. And of course, federal qualified health centers, any clinics, your office where you have a obstetrician or a gynecologist would also be affected by this bill. So definitely, if this does get to conference, you need to address that. I also think the bill is somewhat deceptive in the fact that it seems or seemingly seems to not apply to a small, discrete minority in our community, but in application and in fact, it probably will. When we talk about 7 free pro bono pregnancy centers throughout the state, 1 on Kauai, I think 1 on Maui, 1 on Hawaii Island, that service these women who voluntarily come in for their free services. And I think my colleague from the opposite side of the aisle recognizes that there is a case that we also cite too. I think it was a Georgia or North Carolina case where there was a prohibition against referral to or for legal services. And in that case, I think it still is good law today, but the reference was made to the ACLU legal office in that community. And the woman went there and obtained legal services and was able to litigate and have her day in court. That woman there was cited for unauthorized practice of
Representative DeCoite, would you yield your time?
Yes, Mr. Speaker.
Thank you very much, Representative.
Thank you, Representative for Molokai. That lady was cited for that. The ACLU took the challenge up and basically established the rule of law that in the area of professional services, in this area of professional services, they are not considered commercial speech. And this is one of the sub-exceptions on the area of compelled speech, commercial speech. So that pro bono services, because they serve a clearly important community value and purpose, are allowed in this capacity. So the same principle is applied here for the certified, licensed, registered doctors, nurses, APRNs, etc., who provide these pro bono free services to these women. The penalties are disproportionate to the offense. And this bill would create the only civil cause of action of all the states that have looked at this particular measure. New private cause of action, authorizing an injunction, and potentially awarding treble damages, costs, and attorney fees to the aggrieved party. What would actual damages be on this bill? It could be a pregnancy. It could be a birth complication. Those will be all brought to bear upon the not-for-profit, pro bono, free pregnancy center. They could also be sued for merely not putting up the right sign, having displayed properly, having a electronic form of the copy available, or not having a 8.5 by 11 printed copy available in their waiting room. There are also less burdensome alternatives. I think my colleague from across the aisle talked about the strict scrutiny standard that's going to be applied here. So you look at what's the less burdensome alternative to imposing this requirement of posting these notices in the waiting room in maybe several different languages. Well, the Department of Health already has an advertising budget. They advertise on TV, on radio, on the internet, on banner pop-ups on the web search. Those are all less burdensome alternatives to get the word out that MedQuest offers free or low-cost comprehensive health services to women. It could also be done on advertisements in our daily media sources. social media. It could also be signs posted at all government buildings, WIC offices, Department of Health licensing offices, the BESD office, benefits office, Medicaid office, Social Security office. Numerous places, less burdensome, so these limited number of free centers. Mr. Speaker, I'll be submitting additional written comments, but I just wanted to again go back to when I started my remarks this morning to really thank my colleague from across the aisle. She has done a great job in doing the research, reading the law, and applying it to this particular bill. And I really hope we take her advice and recommendation seriously. I don't want to see us in court on this matter. It may create bad law out of these bad facts. Thank you.
Thank you very much.